So you made an argument, I ruled against you, and you want to press the argument. Have the agreement in front of me, which does have advice of rights form in it. And the amended information looks like it still is the 1F. We're going to later file a 1A, or what's
So I just handed you one with our initials and signature on it.
Yeah, the plea agreement says 1A, but
okay.
the charging document is a 1F.
Can we stipulate then on the record that it's what we assigned to is what it should be, and then they can amend later?
Yeah. So can you file an amended one later?
Yes, Your Honor, I can.
All right, so I'm gonna not give to the clerk either of those amendeds, so that it won't be a second amended, just file an amended information.
1A.
1A. All right, if you can do that within 7 days.
I can do it this afternoon. Shall I email it?
Email it to the clerk's office and to Mr. Williams, and then if Mr. Williams has any objection to it, we can schedule at least a phone conference.
That's fine, Your Honor. 1A, there's no objection for the record.
All right, Mr. Harimoto, would you please stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can be seated. Are you Alex Yoshio Harimoto?
Yes, I am, Your Honor.
All right, Mr. Harimoto, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen very carefully. If you have any questions of me, go ahead and ask. I'm happy to answer your questions. If you need more time to talk to Mr. Williams, just let me know. We're happy to give you that time. Do you understand that?
I do, Your Honor.
Now, I have to advise you the maximum penalty that you could face under this plea agreement. There will be an amended information later that will add a count 7, criminal sexual conduct in the 4th degree under subsection 1A of that statute. And that is a high court misdemeanor punishable by a maximum of 2 years in prison and or a $500 fine. And there's mandatory HIV and STD testing. It's also subjects you to registration under the Michigan Sex Offender Registration Act. Do you understand the maximum penalty, sir?
I do, Your Honor.
Are you on probation or parole anywhere right now?
No.
Okay, were you on bond for any other cases at the time of this incident?
No.
All right. I'm going to go ahead and advise of the trial rates because that advice form is from June of 2019 and it's outdated. There's a May of 2025 one. It's operable. Mr. Harimoto, do you understand if you plead guilty, you won't have a trial of any kind and you'll be giving up the rights that you would have had? I want to remind you of the most important of those trial rights. You would have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. Do you understand that?
I do.
And at that trial, you would have the right to have the witnesses against you appear, and you'd have the right to question them. You'd have the right to present any witnesses in your own defense and have me order those folks to show up. Do you understand those rights?
I do.
Also, at your own trial, you'd have the right to either testify in your own defense or to remain silent and not have your silence used against you in any way. Do you understand those rights?
I do, Your Honor.
Do you have any questions for me or Mr. Williams about any of those rights?
Not at this moment, Your Honor.
Do you wish to give up those rights and enter a plea here today under this agreement?
I do.
If I accept your plea, you give up any claim that it was caused by threats or by any other promises beyond those contained in the plea agreement. Do you understand that?
Yes.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal later, you'd have to seek permission. So this is if you go ahead, if you have a question for your lawyer. Go ahead.
Oh, can you repeat that again, please?
Yes, so by pleading guilty, you lose the right to appeal. If you went to a trial and were convicted, you'd have an automatic right of appeal. And you could raise any issue you wanted, and the Court of Appeals would have to give you their answer to those issues.
Okay.
By pleading guilty, you have to seek permission to appeal. You do so by filing an application for leave to appeal. The Court of Appeals doesn't have to take your case at all. And even if they do, the types of issues you can raise on appeal after entering a plea of guilty are very, very limited. They're much more limited than the kinds of issues you could raise if you were convicted after a trial. Do you understand that principle?
I do, Your Honor.
The plea agreement provides that in exchange for your plea of guilty to the added count 7 CSC in the 4th degree, the prosecutor will dismiss the remaining charges. There's says the prosecutor will recommend a period of incarceration in conjunction with a term of parole / probation supervision, which basically means there's no guarantee of what the sentence is going to be. That's basically everything that's on the table for that charge. Do you understand that?
I do, Your Honor.
All right. And there's been no agreement with this court as to what your sentence is going to be. Do you understand that?
Yes, Your Honor.
All right. Mr. Williams said a full, fair, and accurate statement in terms of the agreement.
Yes, it is, Your Honor.
Ms. Reed.
Yes, Your Honor.
All right, Mr. Harimoto, other than the plea agreement, has anybody promised you anything in exchange for your plea?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
Is it your own free choice to enter that plea?
It is, Your Honor.
Knowing all that, how do you wish to plead to the charge of what will be added count 7, criminal sexual conduct in the 4th degree, person between 13 and 15 years of age?
I wish to plead guilty, Your Honor.
Mr. Williams, would you please assist with the factual basis?
So, Mr. Harimoto, without mentioning the person's name, did you have a mutual but sexual relationship with a person here in Osceola County?
Yes.
Was that here in Rogers City?
Yes.
Was that person at least 13 years old, or less than 6? And during that relationship, did you, for a sexual purpose, have contact with that person?
Yes.
By touching that person, being sexually aroused by that person, finding gratification in touching that person's sexual areas, like such as their breasts or buttocks area?
Yes.
It's here in Osceola County, correct?
Yes.
Your Honor, I believe that's a factual basis.
And at the time, were you more than 5 years older than the person?
I was, Your Honor.
Ms. Reed, you satisfied the factual basis?
Yes, Your Honor.
Mr. Williams, are you aware of any other promises, threats, or inducements?
No, the signed plea agreement has the correct statutory 1A, so thank you.
Ms. Reed, are you aware of any other promises, threats, or inducements?
I'm not, Your Honor.
And Mr. Williams, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, it has, Your Honor.
People agree, Your Honor.
All right. All right, well, Mr. Harimoto, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for March 16th at 11:30 a.m. Here in the courtroom. You'll have to cooperate with an interview and the preparation of a pre-sentence report. And I guess a sexual assault plea having been entered, I'd like to hear from both parties about the issue of continuation of bond or remand. Ms. Reed.
Your Honor, this plea agreement was made at the request of the victim in this case because she really wanted to minimize the circumstances or the consequences for the defendant. My understanding is he currently resides out of state. As far as I know, there's been no, he's made all his court dates and appearances. I don't anticipate that he will not appear for sentencing. I don't honestly have any reason to recommend that bond be revoked at this particular time.
All right, Mr. Williams.
Yes, Your Honor, he actually, he does live in state, but resides downstate. He has put himself into treatment counseling. He's working with the Burgess Group, who works exclusively with the youth sexual offender program in Grand Rapids. I do have quite a bit of experience with that program. He's doing very well, and he has not had any contact or bond pleading to something that does have a presumptive no jail sanction. So I would ask the court to continue bond. I do want a final update for the court from his doctor that's doing the treatment down in Grand Rapids for the court to consider it sentencing. And he's actually participating in the program that the kids who get sentenced to youth sexual offender treatment assignment in Kent County. So he's doing what he would do and all these other youths do. And that program so far has zero recidivism rate. So for all those reasons, I would ask the court to continue his bond.
Well, plea having been entered, Mr. Haramoto is no longer cloaked with the presumption of innocence. Bond is entirely discretionary with the court. There are statutes that discourage it in these kinds of cases, saying that I can't even continue on bond unless there's clear and convincing evidence that he's not a danger to other persons. Here, he was 24 years old and engaged in a sexual relationship with a 15-year-old. I understand there's some dispute about the nature of the school's involvement in that. Not involvement is the wrong word, but I guess Mr. Haramoto's involvement at the school as a non-student volunteer, and that's why the particular subsection the plea was entered into appears to be important to the defense. I don't discount that. But even laying that aside, a 24-year-old engaging in a sexual relationship with a 15-year-old, and this plea agreement is a significant reduction that I had expressed to counsel off the record at a chambers conference that I tend to give a lot of incarceration in these when it's reduced from a first to a fourth. So at this point, I'm going to cancel Mr. Haramoto's bond. He's remanded to the custody of the Presco County Sheriff until further.
All right. May I just address the court on that just briefly? I know
So you made an argument, I ruled against you, and you want to press the argument further. That's generally not how things work. I heard from you both, and I made my ruling.
Okay, thank you.
We'll be in recess. Online. And first off, Mr. Voida, I've got people v. Nicholas Misiak up for an arraignment, file 25-93 386 FH. All right, and I have a plea agreement in front of me as well. For purposes of arraignment, do you and your client waive the reading of the allegation?
We do, Your Honor. We have received a copy of the information. And we believe it's reading.
And is the forensic center referral requested?
No, Your Honor.
All right. All right, Mr. Misiak, would you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put your hand down. Are you Nicholas Jean Misiak?
Yes.
Mr. Misiak, a guilty plea hearing is an important hearing because you waive rights that you have. So I want you to listen very carefully. If you have any questions for me, go ahead and ask. I'm happy to answer them. If you need more time to talk to your lawyer, you just go ahead and say so. Do you understand that?
I understand that.
Now, I have to advise you the maximum penalty for the charge in count 1 of stalking a minor is a felony punishable by a maximum 5 years in prison and or a $10,000 fine and up to 5 years of probation. Do you understand that maximum penalty?
Yes, sir.
Are you on probation or parole anywhere else?
No.
Were you on bond for any other case at the time of this incident?
No.
Did you read and understand the rights listed on the advice of rights form?
Yes, Your
And
Honor.
you signed that?
Yes, Your
Do you understand that that lists the rights that you would have to a trial?
Yes, Your Honor.
And that if you plead guilty, you won't have that trial?
Yes, Your Honor.
Therefore, you give up all those rights?
Yes.
And is that what you choose to do today?
Yes, Your Honor.
If I accept your plea, you also give up any claim that it was caused by any promises beyond the plea agreement or any threats. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission to do so. You would do that by filing an application. Do you understand that?
Yes, Your Honor.
Now, but when you plead guilty, the types of issues you could raise on any appeal are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
All right, the plea agreement provides an exchange for your plea of guilty to that charge. There's a sentence agreement that you'd be placed on a statutory delay of sentence for a year. And during that delay, you'd be subject to different probationary terms. If you completed the delay, then the charge would be reduced to misdemeanor stalking with no jail on that charge. And also that this would be a non-SORA case. Do you understand that?
Yes, Your Honor.
Mr. Boyd, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Mr. McLennan?
Yes.
All right, Mr. Misiak, that sentence agreement is not binding on me. Meaning if I didn't want to follow it I don't know anything about this case. I don't know anything about you. At the time of sentencing, I'll know more. And if at that point I decide I can't live with this, then I don't have to. But if I don't follow this agreement, you would be allowed to withdraw your plea because you wouldn't be receiving what you bargained for. Do you understand that?
Yes.
There is a very important exception to that rule. Here's what it is. If you engage in any misconduct between now and the sentencing, by absconding on your bond, missing a court date, violating bond, committing a new crime, anything like that, then by your own misconduct, you would lose the right to withdraw the plea, even if I didn't follow that agreement. Do you understand?
Yes, Your Honor.
Means you do fine, you show up to court and I follow this, you're on a delay of sentence, no jail, and a misdemeanor at the end if you behave. If you misbehave between now and the sentencing, you show up, I could revoke it and send you to prison. You get that?
I get that, yes.
Other than the plea agreement, has anybody promised you anything to get you to enter this plea?
Not at all.
Has anybody threatened you to make you?
No.
Is it your own free choice to enter the plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 1, stalking a minor?
Guilty.
Mr. Boyd, would you assist with the factual basis? Please?
Yes, Your Honor, thank you. Mr. Mishak, in June of 2025, were you acquainted with a person with the initials of KW?
Yes.
And did the two of you engage in a series of communications during that time?
Yes.
And were you in Presque Isle County at all relevant times during those communications?
Yes.
Was the communication initially a mutually interested communication?
Yes.
And as we stand here today, are you now aware that KW was a minor at all relevant times?
Yes.
Okay. Did there come a time when KW told you to stop contacting her?
Yes.
And despite that, did you continue to communicate with her after she told you not to?
Yes.
Would you agree that she felt harassed by that communication?
Yes.
And would you further agree that a reasonable person might feel harassed by communication after being told to stop communication?
Yes.
And at all relevant times, were you 5 years or more older than her?
Yes.
Judge, I think that's a sufficient factual basis.
All right, you agree, Mr. McLennan?
I agree, Your
And
Honor.
Mr. Boyd, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. McLennan?
Oh, Your Honor.
And Mr. Boyd, in your judgment, has the court fully complied with the requirements of MCR 6.302?
I believe you have, Your Honor.
Mr. McLennan?
Yes, Your Honor.
Mr. Misiak, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for March 16 at 10 a.m. before you leave, you stop in to check in with probation agent here and get her card so that you can make an appointment for a pre-sentence report. You'll have to do an interview so I can learn more about you before the sentence. And Mr. McLennan, any objection to continuation file?
No objection.
File will be continued.
Thank you.
Is that all you have today, Mr.?
That's all.
All
Thank
right,
you.
you have a great day.
You too.
Get somebody on Zoom. Let me see who this is.
Sorry.
All right, and this is, will be Alicia Dockstader. It's two files, 25-93382FH for a docket call and 24-93008FH for a probation violation from the same incident. Here. All right, and Mr. McLennan, is this your case?
This is Mr. Virgo's case.
Mr. Virgo, do you have an amended information for the plea agreement here?
We do not, Your Honor. It would be forthcoming.
I strongly prefer them on the day of.
Yes, Your Honor.
Start doing that because I need to advise of the penalties. So tell me the penalties on your added count file.
Your Honor, my apologies. I would have to, myself, I would.
It would be well, it's a 5-year max.
Okay. Okay, and the fine would remain the same, I think, under the TEP, right? So it's 5-year, 20,000. Okay.
And I noticed on that plea form as I was handing it to you, I think the one file number, the 93308,
Yeah,
that should be a 2024.
yes, that's right. That's right. Ms. Dockstader, would you please raise your right hand, Special Camp for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, put your hand down. All right, Ms. Dockstader, guilty plea hearing is an important event, so I want you to listen carefully. If you have a question, go ahead and ask me. If you need to talk to Mr. Vogler, you just let me know, okay? The maximum penalty in count 4, vulnerable adult abuse, it's a misdemeanor punishable by up to a year in jail and or $1,000 fine. And then added count 5, attempted unlawful imprisonment would be a felony punishable by a maximum of 5 years in prison and or a $20,000 fine. Do you understand that?
Yes, sir.
You are also on probation to me in the 24 file for domestic violence, third offense. That carries a maximum penalty of 5 years in prison. Do you understand that, Max?
Yes, sir.
Did you read and understand the rights listed on the advice of rights form?
I did.
And you signed that?
I did.
Any questions from me or your lawyer about any of those rights? And do you understand if you plead guilty, you'll give up all those rights and won't have a trial?
I do.
Is that what you want to do today?
Yeah.
And you understand you've got the right to have a hearing on the probation violation with the assistance of an attorney as well?
Yes.
Okay. And do you wish to waive that hearing as well?
I do.
All right, the plea agreement provides that I'm sorry, if I accept your pleas, you give up any claim that it was caused by any promises beyond this plea agreement. And you give up any claim that it was caused by any threats. Do you understand that?
I do.
Also, when you enter a plea, in an appeal, you'd have to get permission to appeal, use the right to appeal. And you'd seek permission by filing an application. But the types of issues you could raise would be very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, sir.
All right, the plea agreement provides that for your plea of guilty to counts 4 and the added count 5 that I outlined, and understanding that that would also constitute a violation of your probation, the prosecutor will dismiss the remaining charges. There's a deadline for this that it would expire at the March docket call. So this would remain open for a month if you didn't want to today. And there's a sentence agreement that if I were to sentence you to prison, there'd be a 13-month cap on prison time, sentence within a guideline range of 12 to 24. And that cap would apply to both files, and any sentence would run concurrent. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Vogler, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Mr. Wergo?
It is, Your Honor.
Okay, counsel, if you just understand on the sentencing guidelines portions, the parties can specify a sentence within, they can agree to a sentence within a specified range, and the sentence must be within that range. But I have an independent legal obligation, statutory obligation to score the guidelines appropriately. So how I score them might end up different from 12 to 24. I did not change the scoring to comport with a plea agreement, to stay within a plea agreement, I have to follow and keep the sentence within a specified range.
If I may, Your Honor, then with language such as the parties agree that the guideline range for effectual sentence would be, or something along that line, as opposed to the guidelines will be scored at.
I honestly don't know what purpose this sentence scores in this plea agreement, or you have a cap anyway.
The cap was added later, Your Honor.
Okay. If you didn't have a cap, then it would just say sentence to be within a guideline range of whatever.
Perfect. Thank you, Your Honor.
All right, Ms. Dockstader, that sentence agreement it all boils down to, in both files, there's a cap by this agreement that doesn't mean that I have to send you to prison, but if I decide to send you to prison, then the maximum sentence, the cap on the initial sentence would be 13 months, to 5 years. You get credit for time you've been in. And then at the end of that 13 months minus the credit, you'd be eligible for parole. Do you understand that?
Yeah.
Now that sentence agreement is not binding on me. If I wanted to give you more than 13 months, I don't have to stick to this. But if I didn't stick to this, you could withdraw your plea because you wouldn't be getting what you bargained for. Understand that? That's unless you engage in some misconduct between now and the sentencing. Say that you commit a new crime. Sometimes people do that even when they're in jail. You violate some court order, engage in serious misconduct. Then you'd lose the right to withdraw the plea, even if I didn't follow that agreement. Do you understand?
Yes, Your Honor.
Other than this agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 4 of vulnerable adult abuse?
Guilty.
And how do you wish to plead to what will be an added count 5, attempted unlawful imprisonment?
Guilty.
Your Honor, if we could just pause for a second.
Yeah.
And I want to talk to her a little bit about those guidelines, thing that we just went through.
Yeah, that's fine. Oh,
It's important because the 12 to 24, of course, leaves open the possibility of a county CAT or a county jail sentence without any deviation. So I want to make sure she understands clearly what.
Oh, okay. I see what you're saying. Well, okay. Then that maybe helps me understand there is a purpose to that sentence. So I just want you to understand, I'm interpreting that sentence, the sentence in the plea agreement, that any sentence I imposed would have to comply with both a 13-month cap and would have to be within a specified range of 12 to 24 months. So even if the guideline score is 16 to 38, this plea agreement means the sentence must be within a 12 to 24 month range. Still leaves open.
All right, very good.
One other question I had, the principal offense of unlawful imprisonment does have a SORA notice. I don't know if the attempt would do so or if this is a SORA case.
I don't believe it's a sort of case as I review it. There's no
And,
minor involved
yeah,
here.
and there is there was that case that said as applied to non-sexual offenders, it's cruel and unusual punishment. So I would not treat this as a SORA.
I don't think that would be, that we're at risk at that.
Okay.
And the people stipulate this is a non-SORA case.
All right. Did you need a minute with her?
No.
Okay. All right. So, Ms. Stockstader, back in August 27th of last year, were you in Presque Isle County?
Yes, Your Honor.
And were you caring for a Victoria Dockstader?
I was.
And who is that person to you?
It's my mother.
Is she a vulnerable adult in some
She
way?
is.
In
yeah.
what way?
She's disabled. She cannot walk.
Okay, were you providing care to her, physical care to her?
Yes, Your Honor.
And did you take away her walker and her telephone?
Yes, Your Honor.
And did that prevent her from, did that restrain her movement?
Did.
And did that prevent her from telling somebody where she was at?
Did.
And you did those things without her consent?
Correct.
Mr. Vogler, do you believe that satisfies the factual basis for both charges?
Your Honor.
Mr. Wergo?
I do, Your Honor.
And Mr. Vogler, oh, I'm sorry, and Ms. Stockstader, you understand that part of your probation was that you not violate the law?
Yes, Your
Okay, so do you acknowledge then by your behavior with Victoria that you did also violate your probation?
Honor. Yes.
So Agent Leskey, as I'm looking at the warrant, her plea today establishes count 5. And so I'll just dismiss counts 1 through 4 and 6. And count 5 is a non-technical violation. All right, Mr. Vogler, are you aware of any other promises, threats, or inducements?
I'm not.
Mr. Virgo?
None, Your Honor.
And Mr. Vogler, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes.
Mr. Virgo?
The court has.
All right, Ms. Dockstader, I find that your plea in both files is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those crimes. So I hereby accept your pleas. Okay, I'm gonna set sentencing in both matters for March 16th at 9:50 a.m.
Your Honor, I would ask at this time, given that her plea has been entered, whether or not the bond restriction with her mother, sister, and whoever other family members be lifted. There was a PPO against her, and I think her sister and her mother both came in and asked the family court to terminate that. It was done last week.
Mr. Woodrow?
That is my understanding, Your Honor. The people would not oppose.
So I'll write on this docket call order. Bond remains revoked, but no contact provisions removed. And to the extent that you find that the jail needs something additional beyond that, you can get a copy of that, then you can just submit it.
Thank you, Your
All
Honor.
right, thank you. And have you had a chance to talk with Mr. Board? Do we want to do that?
Mr. Gilbert,
This courtroom hearing takes a serious turn as the defendant pleads guilty to vulnerable adult abuse, a misdemeanor, and attempted unlawful imprisonment, a felony punishable by up to 5 years in prison and a $20,000 fine. On top of that, the defendant is already on probation for third offense domestic violence, meaning this plea also counts as a probation violation. The plea deal includes a 13-month prison cap. Even though the guideline range is 12 to 24 months, the judge makes it clear by pleading guilty, the defendant gives up the right to trial and most appeal rights. Now the big question, will the judge stick to the cap or go stricter? Comment your thoughts below and don't forget to like and subscribe for more real courtroom breakdowns.